Good morning, Ms. Mammon. Mr. Kirkman?
Thank you. May it please the Court, my name is Tom Kirkman. I represent the Commonwealth in this case. Just at the outset, I would like to say that the standard of review for this case is constitutional error or prejudicial error. There is a claim of a constitutional violation, and while the appeals court
So you're saying that they were sort of off a little bit on Hill? And
upon further analysis, I believe that's the case. I don't think this is a substantial risk case. I think it's the prejudicial error standard. In any event, identification is the main issue in this criminal case. And one thing I would like this Court to really focus on are the other witnesses that testified at the trial identifying the defendant. There were at least 5 of them.
But what does that have to do with whether or not we admit the testimony of the shower?
Well,
we don't look to the reliability of it, correct?
That's correct. Even if we totally disregarded the victim's identification of this defendant under any circumstances, there was still other evidence before this jury.
That may go to whether or not there was, whether it was prejudicial, correct?
That's correct.
I mean, so that what you're saying is, just so that I understand you, even if this shouldn't have been admitted, it's not prejudicial beyond a reasonable doubt.
That's correct.
Okay, fine.
And there is a 3-stage analysis to go through in deciding whether.
But, excuse me, in your brief, didn't you suggest that the existence of the other witnesses somehow confirms the independent source rationale?
It certainly.
And how does it confirm it? How does it confirm the independent source rationale?
Well, the victim in the case, our argument for independent sources, the victim in the case clearly identified the person at the trial, that she had an opportunity to view the defendant, and once she got into the courtroom, that should stand on its own, and it's simply a matter of her credibility. And I think this is an important point.
Okay, but you haven't answered my question. How does the existence of the other witnesses confirm the independent source rationale, which is what I thought you argued in your brief?
I did argue in my brief, and perhaps I was awkward in the argument, but the point that I was trying to make is that it really goes to the prejudicial error, that the victim's identification is valid, and this is how we know that.
How can you say the error wasn't prejudicial here? I mean, it's clear from the jury deliberations, is it not, that identification was what hung them up?
There is no question the jury sent out a question that the identification was a problem for them. I don't know how much we can read into that, because we don't know if it was a single juror who was holding out.
It doesn't make any difference, right?
Well,
in other words, we never ask that question.
Right.
What we do ask is there any question, or if there is a question from the jury, what impact does that have? Often, I don't know if there are any cases, and maybe you can help me, whether there's been any case where we said the standard is prejudicial error, there has been a jury question on that very question, and we have said no prejudicial error. Do we have such cases?
I'm not aware of any cases, and I have to confess that I'm not aware of any supporting authority for my position or contrary authority for it.
By skipping right to the in-court ID, are you suggesting that you are conceding that the original identification was the result of an unduly suggestive show-up procedure?
Not at all. And that's a very critical point that I want to focus on, and that is the trial judges. Judge Dolan's findings, very specific findings in her ruling on this motion. This didn't just happen in the courtroom. There was a hearing. There was a very detailed and very specific findings of fact and application of the law.
It seemed to me, at any rate, that some of Judge Dolan's findings go to why she thinks this is reliable. In other words, I thought in the Commonwealth the law was very clear. You look to the strength of you look to see whether it's unduly suggestive. You don't look to see whether it is otherwise reliable. And Judge Dolan has findings, and that's the difficulty. She has findings that go to reliability.
Well, I the way I view those findings, or at least the way I would analyze those findings on reliability, is they tie into the independent source. If I read the case law correctly...
But she's not here dealing with the in-court identification. What she's dealing with is what, at least as I understood the motion to suppress, is was this show up in the circumstances unduly suggestive? And she goes to, and she deals with that, but in part she deals with it as to why she's not concerned because this is reliable. She thinks the testimony is, the identification is reliable.
She certainly references that, but she goes through the three-stage analysis. She starts out making a finding that the defendant did not carry the burden by a preponderance of the evidence to show that this was unduly suggestive, thereby triggering the per se exclusion and the clear and convincing evidence that the Commonwealth then has to present. But then she goes on in her decision and says, but even if the defendant has met the burden, the Commonwealth has proved by clear and convincing evidence. And then she goes on and says, and even if the Commonwealth hasn't done that, there's an independent.
Explain to me why this isn't unnecessarily suggestive. I mean, I like the word unnecessarily. It's the word that's used over and over again. It has nothing to do whether there's some impropriety. It's just unnecessarily suggestive. 4 days after the incident, she said, we have a suspect we want you to look at, brings her down to the beach. There's a suspect. There's her father right next to the suspect. She understands her father has picked this person out. Why isn't this exactly what the court meant when it said unnecessarily suggestive?
And on the other side of the coin, to Justice Cordy's question, was there any special need? Why couldn't there have been a photo array or bring the person in for a lineup, one of the two things?
And how do you bring a person in?
Or a photo array, if you can't bring them in.
Well,
you can
I'll try
choose
to
to answer any one of those.
I'll try to answer them. I'll try to answer them in reverse order, and that is, I don't know how you bring someone in. You have to invite them in.
And if they don't want to go in,
and if they don't want to go in, then you're kind of stuck.
But you can have a photo array.
Well, if you can get them to stand there and pose for the picture, that's correct. They had already showed her a mugshot that didn't match up. But in answer to Justice Cordy's question, why this is not unnecessarily suggestive, it's because of the unique circumstances of the case. This is not a case, as Justice Dolan pointed out in her memorandum or her findings, where the young woman reports the incident to the police, they make a drawing, and then 4 days later they say, oh, now we think we found this fella. Let's take a look at him. This was a ritual. The police were obviously very, very concerned because every single day they were driving around.
Well, then, does it follow that in future cases, if we agree with you, if the police start to just every day take out a victim to go look, then it would be okay to do a show-up 4 days, 5 days? When would it stop?
I don't know, because under Levasseur, it was 2 weeks, followed by 6 months later.
And if we adopted your argument, we would really be adopting, in practical fact, a test that would be different for rural, suburban areas of the Commonwealth than for cities, because in a place like wherever Yarmouth, the police can afford to take a victim out day after day after day. In big cities, they can't. So
can I get a clarification?
It would be a totally different test.
The facts, because I, in terms of what was going on during those 4 days, was she just driving around with the police, sort of driving around town looking to see, or had there been other one-on-one show-ups during those prior days?
According to the findings of fact by the trial court, they appeared to be driving around. I don't know that it was 8 hours a day or anything like that. I think when they felt they might have a suspect, they drove around in general areas, and she saw a lot of people. And there were at least 6 individuals that they kind of pointed out. There were 2 individuals prior to this one, prior to the defendant, that the police actually stood next to and did a very similar type of show.
But that's the problem. But that's the question. Is it that while she was driving around, which is very different than being brought saying, we want you to look at a suspect. Driving around town, do you see anyone who looks like it might be the person, is extremely different than taking someone to a place to see a suspect. But is it that she saw people, and then if she thought they might look like the police got out and asked them to stop so she could get a closer look?
That is
Or-
not clear from the record.
Mr. Kirkman, can
yes.
we just step back? I mean, it seemed to me that there are at least, three public policies. One is the real problems that we know exist with respect to identification. So the unreasonably suggestive is not because, we think the police or victims are doing anything incorrectly. It's because we know that identification can be a problem. That's number one. Second, there's the problem about, which I think Justice Spina is alluding to, where people are just randomly selected, not doing anything incorrectly, not in the immediate aftermath of the crime. Somebody calls the police, says, I just saw somebody run away, she had a red, baseball jacket, and they find somebody in the next block. Very different. Even then, we are very hesitant about that. And the third thing is making sure that, in fact, we apprehend people who've done really terrible things in the community. And it seemed to me that the notion that the police are driving around, not only with the victim, but with friends, parents, colleagues of the victim, just going through the community saying, this is how I'm describing the person, and any time we see anybody that we think the victim thinks would be the person, we can apprehend them and set in play. And it seems to me that there's something inherently problematic about that.
I would agree with the court if, this didn't happen in this case, if her father had been in the vehicle or friends or colleagues or anyone like that.
But everybody's fanning out into the community. Here's this picture drawn from her best thing, and we fan out into the community, and if we see anybody that we think matches this description, call the police, get the police over there, and then get the victim to come. Something says to me that's not the jurisprudence that we want. It's particularly problematic here because, in fact, it's not entirely clear that this case wouldn't have existed but for that. I mean,
the composite, was that sort of itself widely circulated, or at least the father had the composite?
The composite was widely, my understanding of the record is the composite was widely circulated and published in local newspapers.
Which is in fact intended to invite people, if you see someone who looks like this, please notify us.
Exactly.
And certainly there's nothing wrong with that. We
There's
want
nothing-
that in
there's
the
nothing wrong
aftermath
with
of a
that.
crime.
There's nothing
Fine.
wrong with that, and I would suggest that the father in this case, according to the record, was not standing next to the defendant. He identified he picked out the defendant, called the police, and they came down. He had the same information that the police had, which is just a composite to go on, and the attack on his daughter.
And I take it that Judge Dolan, obviously, and we can't, was able to look at that composite and this defendant and get some idea of how close
It
they
appears
were.
that way based on what she wrote in her findings.
When
The
was
composite is in the record.
When was the first time that the victim mentioned the identifying mark on the defendant's forehead?
At the scene of the show-up. She
At
did
the
not
scene
mention
of
that prior to it. At the trial, she said, when examined, that his hat had slipped back during the attack, and that's when she had noticed it. But she did not.
Would you have a case being able to make out a special need for a one-on-one show-up by saying that they had already shown her a picture of the suspect in an array, and she had not picked him out, of this defendant, and therefore if they showed her another picture, another array with his picture in it, that would be considered suggestive because we've said you can't keep showing a victim the same picture over and over.
well, it's not the same picture.
Well, the same person over and over.
Yeah,
I wonder if you could make out a special need by that argument.
Well, I don't know, and I'm not sure if I'm clear on it. In this case, she had been shown the mug shots and the defendant's picture, and again, those are in the record, Appendix 2, and when you compare the mug shot with the picture that was in the photo array that she looked at later on the day, they really look like very different people.
Mr. Kirkman, what have we done when we sent out flyers and we say, phone if you see this person? I mean, we don't have cases where you have this kind of show-up, correct? Or do you?
I'm not aware of any, but in answer to your question of what have we done, the protocol is you send out the flyers, the police get called, they interview the person that calls them and says, why did you call? And they say, well, I think, that person over there is the person on this flyer.
And the police go, and they're perfectly entitled to, and they say to somebody, can I talk to you? Right?
That's correct.
And, there's nothing wrong with doing that.
No, and of course...
And there's nothing to suggest here that that's what the police did, correct?
Well, the police apparently did do that, and I notice that my time is running out, but I'll certainly answer your question. What the police did is they get the call in, and apparently, again, it's not that clear on the record, but there are two officers talking to Mr. Martin out at the beach area, the parking lot, and then this other cruiser pulls up, and they say, there is someone here we want you to look at. And the young woman looks across, and she sees the two officers, and she sees that individual, and then asks that he be brought closer to her, and that's when she makes the identification.
Does the record reflect whether the father was present at the time the victim was shown, other people, other suspects, or other...
The record does not reflect that, and...
I thought Judge Dolan, in fact, said he was there. He was
at the beach for the final show-up, but the other show-ups that occurred, the two others where there were police officers standing next to the individuals, or the four others than that apparently there was a specific individual that was viewed. The record is not clear that the father was present during that. And Judge Dolan, of course, highlights, as has the defendant, the problem with the father, but I would simply suggest and close, unless there are further questions, that the father was acting like nothing more than any other citizen, or even the police. If there had been a Yarmouth police officer who had happened to be at that parking lot that day, knowing there's this composite, knowing that they're looking for somebody, it would have been...
No, that isn't fair, because the father has more influence over the daughter than a fifth policeman does.
Right, but all it communicates is somebody thinks that this person resembles the composite she had drawn.
That's correct.
But
I
she
don't
knew
think
that
that's
her
right.
father,
Yeah.
she concluded that her father had identified this guy, right?
That is correct.
And
That's
her father
absolutely
is a
correct.
much more meaningful presence there than another police officer would be.
Well, and that, of course, leads us back into Justice Dolan's findings about the capability of the young woman to be swayed by people in authority, or even her father. And she makes a finding that the judge herself asked the victim during the hearing certain questions and said that she didn't seem to be particularly swayed or guided towards any answers. She had a certain poise about her.
Well, that may go to its reliability and ultimately the independent source, but I'm not sure it goes to whether this is unnecessarily suggestive. Okay.
Thank you, Mr. Cook.
Thank you very much.
Mr. D'Angelo?
Good morning. In this case, the appeals court said that the identification procedures fell completely outside the realm of cases that have been approved in the past.
Mr. D'Angelo, why? I mean, you know from the questions.
Yes.
We send out flyers all of the time. We put them up on post offices. We get the best composite that we can. We take photographs of people as we think they now would look, and we say to people, please call the police, right?
Yes, Your Honor. The suggestiveness doesn't arise from the flyer. The suggestiveness arises from the circumstances at Veterans Beach. And the unique facts about this case have to do with the presence of the father. On page 27 of the record, Judge Dolan finds the father was standing a short distance away from Mr. Martin when Ms. Boudreau arrived at the scene. On the way to the show-up, Ms. Boudreau...
Right, but the father wasn't a witness to the crime.
Yeah. Yes, Your Honor.
That would have had some special thing. This, apparently, Judge Dolan makes the assessment, this is a fairly savvy and smart young woman, and all she would understand from knowing that her father had picked him out is, my father thinks this person looks something like the composite that I drew. How is that particularly suggestive?
Your Honor, the cases have found that even the presence of a police at a show-up can be suggestive. Here's a very powerful suggestion to a 15-year-old girl that her father believes this is the one who matches the... So there's not only the circumstances of being taken to the scene, told there's a suspect, brought to Mr. Martin, but there's the presence of the father.
Everybody who goes to, be it a show-up or any kind of show-up, knows that somebody thinks that the person you're about to look at bears some resemblance to the person who's been described or to the composite or whatnot. That is inherent in every show-up.
And that's why show-ups are disfavored, because they're very powerfully suggestive. So that in order for them to become admissible, there has to be good cause, and there's no good cause here to... I didn't mean to cut you off.
So you understand, we send out the flyer, you say no problem. We understand that the police get reports, I mean, lots of reports. We think this person looks like... What do the police then do?
Your Honor, let me address the question. You're really asking why was it unnecessarily suggestive. It was unnecessarily suggestive because the father didn't have to be there. He could have been told to leave.
No, but let me put it differently. So one way you can say is bring her here, get her here fast. No police officers present, right? Father's not there.
Well, that's how do you have no police officers present and
just
have the
say
defendant?
the man is walking, so we're going to, we have radio communication and we're following him down, and this is. Why would that be any less suggestive? In other words, she's told, we think we have a suspect, and he's walking down the road. In this particular case, he was in a parking lot, so the police approach him. I'm not sure, by the way, that that's something that the police shouldn't do, right? Because you can always go up to a citizen and say, can you tell me where you were on the night of something other? There's nothing wrong with the police doing that. What you're asking us to say is get the police back into the car, get the father out of there, and she just is driven past and saying, this is somebody who called in and we think we might have seen this man?
She wouldn't even have to be told that because she had previously been driving around just looking at people.
But you're conceding, I take it, that it's the unique circumstances of this case that make it unnecessarily suggestive, and that had they been police officers who brought her up to see this person, it would not have been unnecessarily suggestive. That's what I understand you to be saying.
I guess what I'm saying is in this case, those unique circumstances take it outside the realm. I think there are other factors here, the lack of immediacy, the 5-day lapse, actually.
But do you concede, do you agree that if they were police officers that had taken her here after seeing 5 or 6 others over the span of 4 days, that it would not have been unnecessarily suggestive?
I wouldn't agree with that because I think still she wouldn't have had to be told there was a suspect.
But then how are the police to proceed when they get information that there is somebody who resembles a suspect? And this seems to be an instance where the police do need to act because there have been several people who have reported that they were approached by this man, not actually assaulted, but approached by this man. So the police, it's going to be a serious problem if they don't do something. They'll be at fault. So how could the police proceed that would not have been unduly suggestive in this way?
Well, I have a specific and a general answer. The specific answer is that the special elements in this case could have been eliminated. The presence of the father, the uniformed cop, the being told that there's a suspect. So this case
well, what do they tell her when they pick her up? I mean, you can't just go to somebody and say, hey, come with me.
Well, actually, in this case, they could because that's what they had been doing. They've been driving her around.
So you're saying they could have had radio contact and said, we're just going to follow this man, presuming that he stays on a public way where a cruiser can follow him, and just say to her, come right now, no, right now, come right now. We're going to go in this direction. There's only one person there, maybe, and say, do you see anybody? And I think I understood your answer to Justice Spina saying that would be unduly suggestive.
Well, actually, the record establishes that they had a pre-existing appointment with her on this morning by coincidence. They had previously been driving around with her, through the streets of Hyannis, places where homeless people are likely to congregate. They could have done the exact same thing here, not told her they had a suspect, just taken her to Veterans Beach, driven into the parking lot, driven by Mr. Martin, who was could have been standing next to a plainclothes cop.
Then even she herself says, I need him brought closer.
At that point, they had stopped.
I mean, that sort of she needs a close look at him, not just a drive-by, apparently.
Well, that she can get. There's nothing suggestive. And so
but the only way she can get that is if they do police around him to say, hey, come closer.
She's in the car, and they get out, and they say, would you mind coming over here? And either he says no, or he says yes.
Well, in view of the Court's policy concerns, I also want to address the general response, which is that show-ups are disfavored, they're disfavored because they're unreliable, and they create unreliable evidence. Now, there's a difference, and this Court has recognized in the immediate aftermath of the case. As we move beyond that, and certainly 4 or 5 days is well beyond that, show-ups are very problematic, and I address the Court to some of the writings by the New Jersey Attorney General's Office and DOJ cited in amicus and our brief.
But what you're saying is, however, that you can do, that they could have done a form of show-up here, but that they had to engineer it in a way that would take out some of the suggestive elements that are usually associated with show-ups. Do I understand you're not suggesting that they had to try to do a physical lineup, or that they had to do a photo array, which is not as good as a lineup, that they had to do, you're saying they had to engineer a better show-up than they did?
I think in this case it would be sufficient to find that the show-up, that the features of the show-up that made it so suggestive were unnecessary.
I take it that you're saying you can have a lineup. You have a lineup of one person. We've said no, you've got to have a lineup of more people. Then you have the only white male, and you have the 6 other people of, black or Hispanic or something else. And you say, no, you can't do that. So we've essentially tried to scrub. So if you're going to do a lineup, you make it as neutral as possible. You're saying you can do a show-up 4 days later, presumably, but you have to scrub it as much as possible, and nothing was done here to remove anything.
I don't think I'm saying we can do a show-up 4 days later. I'm saying that the 4 days in this case was a feature, and the special features, the father, the uniformed policeman, the statements, all of those were unnecessary, and in view of the 4 days, more problematic, because immediacy is important. And I think that the sort of random sightings that had happened during the 4 days where she's driving around, they're so different in kind.
When we do show-ups that are in the immediate aftermath, we've never said, oh, police, you've got to just drive the person by and not have police standing near him. We have accepted those features when it is in the immediate aftermath. Even though, from what you're saying today, we could, to use the Chief's term, we could scrub those too and say, oh, yeah, you can do a show-up, but you've got to, hide the officers and just drive the person by.
But you can't do that.
So why is it different 4 days later? If you don't have to scrub it on day 1, why do you have to scrub it on day 4?
You can't get rid of the police. When you're dealing with somebody who may be dangerous, you can't leave the person there and have all the police disappear. It's just unrealistic.
If I can address Justice Cowan and then Justice Sussman's question, you could in this case have gotten rid of the uniformed police officer so that from Ms. Boudreau's perspective there wouldn't have been a police officer because there were plainclothes policemen on site. With respect to why does immediacy makes a difference, as this Court has said, because part of the problem with passage of time is that confusion ensues. And in this case, that 4 days, there was numerous instances of confusion, not just the random sightings and the looking around. She looked at mugshots and did not pick out this individual. She gave a composite, and it's just as clear as paper. To look at
by the way, do you agree that the mugshot of the defendant that she looked at was different in that his face was thinner and he had facial hair in the initial photograph she looked at?
What number was he? I could not
Okay,
tell
on record 41, which is
right.
he's number 8. That's how he looked on the day of the arrest.
Okay.
42 is the mugshot. I would say he does have facial hair. I don't know that he's thinner. But I think the important thing is on record 40 is the composite. And it's quite clear there's no mark on his forehead.
Right, but to what other extent, though? I mean, again, Judge Dolan had some sense of this. We can't. To what extent did that composite, otherwise, in all other respects, look like the defendant?
Well,
I mean, it seems to me that her finding about the quote remarkable accuracy was based on that the composite really looks like this guy.
But,
and yes, one mark may be missing, but otherwise really looks like this guy.
The mark is very significant, and
where
in
is
truth,
the mark?
you can't distinguish Johnson.
Where is the mark? It doesn't show up on the mugshot picture. No, on the mugshot. I don't
Not on
see
the mugshot. On page 8.
So how obvious is it? If it
Well,
doesn't
on
even
page,
show up?
well,
Page
first
42. I'm looking at the mugshot on page 42.
No, there would be no mark in 42 because that's the earlier picture. On 41.
No. I thought that was the 42 is the present mugshot.
No, 41.
41, number
41
8.
is the photo array.
I know that's the photo array, but on 40, I know that's.
Arrest.
That is number 8 on 41, that's after his present arrest?
That's after the arrest, yes.
I take it
This list.
I take it the police had no right to pick him up and put him in a lineup. Can you do that?
There was no argument that they had probable cause. There was no assessment, no findings.
You'd need at least probable cause to pick
Yes,
somebody
well,
up.
actually, there's also no evidence that they asked him. There was no evidence that they asked to take his photo. But as I said, in determining what the police should do, the court has to be mindful that the needs of law enforcement have to be considered in light of the unreliability of the show-up, so that although the police might be in a quandary, the solution isn't to create tainted evidence or to do a procedure that can really lead to wrongful conviction. But in this case, the court doesn't even have to go there because the show-up did not have to have the special features that distinguish this case from all the others.
If there was some suggestiveness, if there was suggestiveness from the method by which this was taking place, did that suggestiveness dissipate over the number of incidents that occurred? In other words, this had taken place, 6 or 8 times over 4 days. And you know, to the extent that there may have been some suggestion that the police thought that a certain person was the guy, by the time she had seen 6 or 8 of them, I mean, that kind of influence certainly was washed out, wasn't it?
No, I think the evidence is clear that those previous things were very different. Detective Ziaras referred to them repeatedly in his testimony as random. They were driving around, as I said, driving around Hyannis or Yarmouth, and they'd pass by a congregation of homeless people, and they might see a male who fit the very general description, you know, between 30 and 45, white, thin, and they'd say, anyone here? On a couple of occasions, there were police who had come to assist. It was not clear from the testimony that the police had even singled out this guy beforehand. And, of course, in none of these in the record is quite clear the father was not present.
Can we move to another subject, and that is, let's assume for a moment we accept your argument that this was an unnecessarily suggestive show-up, and therefore, under Johnson, is per se not admissible. Now we go to her identification at trial.
Yes, Your Honor.
And we go to the independent source rule.
Yes, Your Honor.
Why isn't there an independent source here? It was a daytime assault. She saw him face-to-face for 3 minutes. A remarkably accurate composite, leaving aside the one facial mark not included. The judge found that she was very credible, reliable, all of the sort of qualities you'd want in a witness. Why isn't that enough?
Okay. I'll address that with specific facts. I do want to note, though, that the admission of the show-up in itself is the admission of the testimony of the show-up in this case is so prejudicial that it would require reversal of this case.
I understand.
With respect to why there's no independent source, I think the clearest answer is Johnson, that she based her identification of him on a mark on his forehead that she had not previously said. Record 40 shows a composite that does not show the mark. The court would have to overrule Johnson in order to say there was an independent source here, because in Johnson, on the independent source issue, the court said a victim who based an identification on a suspect's bad teeth, when she had not previously mentioned bad teeth, is the flimsiest kind of evidence that should not have been admitted at trial. So that, plus the fact that there was
Was there a composite in Johnson?
No, but I think the composite hurts the Commonwealth because it doesn't have the mark. And again, the composite reflects the very generalized description. It reflects a middle-aged white man. That's what it is. It's a middle-aged white man with no facial hair. It's not remarkably accurate, other than the fact that, in fact, at the time of his arrest, he was a middle-aged white man with no facial hair.
And no mark.
And no mark. She didn't know the color of his eyes. She didn't. A lot of the specificity was about clothing that he wasn't wearing at the time of the arrest. Let me finally address the standard. I appreciate the Commonwealth's concession as to the standard of review, and I would ask this court to clarify that, because Hill has created a problem for practitioners. It's a trap for the unwary. In terms of how it plays out in this case, I think it would be impossible to say that the evidence other than Ms. Boudreau's testimony was of a magnitude that this would not be harmless beyond a reason, that the Commonwealth establishes harmless beyond a reasonable doubt. All the other witnesses establishes that Mr. Martin was around the neighborhood within the days preceding the incident. The only other precipient witness, Mr. Piasta, who came to rescue Ms. Boudreau, he looked at 2 photos, one of which might have been one of which was Martin's, but he leaned toward the other ones. Absent Ms. Boudreaux's testimony, this case would not have passed Lattimore. It certainly would not have been harmless beyond a reasonable doubt.
What about his written notes? Didn't he have some scribbles?
Yes, Your Honor.
Well, you're not suggesting that's not admissible.
Yeah, you were just...
I'm not suggesting that's not admissible, but again, it just establishes that he was lurking,
Under
but he was
Lattimore,
camping.
under
He was camping in
Lattimore.
the vicinity.
How can you suggest, or you seem to suggest that he might have had a larcenous intent when he attacked her, but this is a young woman on the beach, and she was carrying at most a small purse. How can you suggest there's a larcenous intent?
To the final issue that I raised in my brief, that in order to establish specific intent, the Commonwealth has to have some evidence here where there's no sexual touching, there's no sexual words.
Well, there were the notes.
And he's
In the
dragging her off, not
Yes, Your Honor.
grabbing the
And he
That's
didn't grab her purse. There was no evidence that he grabbed her purse, so I don't see how you can suggest there was anything other than a sexual agenda here.
Okay, but I was responding to Justice Ireland's question as to how the notes would play into harmless beyond reasonable doubt. Even if they edge the Commonwealth closer to the Lattimore standard on ID, and I'm talking about ID here, they don't establish harmless beyond a reasonable doubt. With respect to the specific intent, I think that Derby and Marr, which are the cases Justice Cowan is relying on, they're somewhat distinguishable because there was some affirmative evidence that the assailant didn't grab for something. Here, there's not that evidence, and so that's
Well, he
my
didn't
argument.
grab for her purse.
He didn't, but he did
And
not
there was
grab for
nothing
the
else
purse.
when she's at the beach. What else is...
There's a very brief struggle, so there's no question. There's no evidence as to where the purse was during the thing. So based on that, I would ask the court to reverse on the ID, and I rely on my brief for the other issues. Thank you.
Thank you, Mr. D'Angelo.